My name is Scott Moskell. I'm a senior partner at Burns & Levinson, and I run or co-run our cannabis law practice. And what Laury asked me to do was come in today and kind of give you a little background as to myself and kind of Burns & Levinson, and how do we practice law in this new area of cannabis, and what does it even mean to be a cannabis lawyer. And so I hopefully, and then just touch on some issues that we face daily. This presentation, I think, is probably more practical than legal, in the sense of I'm trying to come at this from the perspective of, y'all are going to be lawyers at some point, practicing lawyers, and kind of give you an idea of what I do and what my team does from day to day. So we actually have anywhere from like 12 to 15 lawyers of our 120 lawyers who practice cannabis law, at least I would say 40 to 50% of their time. And so that's how much work we're bringing in. And so I assume for the most part, most of you all are here because you're interested in this new area. It's one of the biggest, booming, hottest practice areas, that is in the legal practice right now. And so either at the end of this, you'll want to continue to seek ways to practice, or you'll run screaming and never want to do this ever again.
Hopefully not.
I don't take myself that seriously because life's too short. And so I just want to put people at ease, ask questions. This is sort of your hour. I'm not sure how you ask questions on this platform, but
they're just jump in. I try to look for hands, but it's hard.
Okay. Well, then however we go, let's get this program started, and God help you all. So, I did prepare this PowerPoint, and it's probably more of an outline than a typical sort of PowerPoint with lots of information. But what I wanted to start off with was more practicalities. So more about the legal practice. And as you all know, and we have to say this as lawyers, whenever we're talking with potential clients, cannabis is federally illegal, et cetera, et cetera. So what we do, and this is more a practice point, I've taken out a couple of particularly important paragraphs from our engagement letter. So when you're a lawyer, one of the first things when you get a new client, unless you're with me and have pro bono clients, which you forget to do this with, you have an engagement letter. And as Laury could attest, one of my pro bono clients. But we do have engagement letters. And with our cannabis clients, we put these particular paragraphs in there. And this is sort of self-preservation, CYA. But I think, it's important for you all as you practice, not every law firm may be thinking in this way. A lot of times there's a uniform engagement letter, but if you're going to engage with anyone who's in any way involved in the cannabis industry, I mean, this is the best proof that you have complied with your ethical obligations to essentially say it's illegal, by the way. And so feel free to rip this off in any regard that you would like. But I can't stress how important this is, that you make sure you comply with ethics, even though we're talking about being drug runners. Legal. So why I bring this up is the Boston Bar Association and the overseer, or whatever it's called, the bar overseers. They released this policy in 2017, and essentially you can't be disbarred for helping medical or adult use marijuana companies, or I should say cannabis companies. You can't help them, divert to minors and things like that, but advising them as to, how to set up a company or what their legal rights are under the state law regulations is something that you cannot be disbarred from. So that's always a good thing. For a while, this came in 2017. And before then, we would get lots of calls. Well, aren't you guys worried that you might be disbarred? I always said, well, that might be a blessing in disguise some days. But just to give you all some comfort, you can freely practice in the Commonwealth. And most other states have actually instituted something similar. So just keep that in mind, but that's why you have to comply with your legal ethical obligations to warn it's federally illegal. All right, so about me, about our practice, I could spend 40 minutes on it, but so I graduated in law school from Emory in 1992. And I know you're saying, God, you look too young to, but anyways, and what I did my first year after law school was I thought I was going to be an international lawyer, not knowing what the hell that actually meant. And so I spent my first year after law school, my first job was working for the Sars Foundation. And I went to, in 1992, to this Black Sea city called Varna, Bulgaria. It was in Bulgaria. And I taught law or in Bulgaria for a year and kind of helping with their civic education project and promoting sort of the concept of the rule of law. And it was still under the communist government was still, remember 1992, the wall had just kind of fallen. Russia, Soviet Union had fallen, now it was Russia. But in any regard, it was still a communist society. And we could spend hours talking about my life there, but that's kind of not what we're here for. From there, I started working in a very small law firm in Providence, Rhode Island, which is where my family's from. And I went back to school. Went back to live after coming back home from Eastern Europe. And what I started off doing was being a bankruptcy, corporate lending, financial lawyer. And I did that for about 3 years. And then I kind of had one of my first of my many midlife crises, which apparently I have every few years. And I said, you know what, I'm sick of this law firm crap. I just wasn't for me at that point. So I went to back to school and I got my doctorate in political science, passed my doctoral comps. And, it was all but dissertated. It was about right, was starting my dissertation when my advisor died. And sadly, and just as folks may know, when you're that far along the practice and your advisor passes, well, it's not necessarily a good thing. So I went back to practice law again, God help us all. And I moved to DC in 1999 and worked for a mid-sized law firm doing a lot of corporate and insurance and bankruptcy work. And I was in DC in 2000, 2001 during the last time an election was contested, as likely to be contested this year. From there, I went to Mitz Levin in Boston, was an associate and senior associate in the bankruptcy workout group. And then in 2007, I moved to Lehman Brothers, where I was in-house at Lehman Brothers, a senior counsel level VP. And I was attached to a platform that we had about $1 billion in non-performing or sub-performing commercial real estate loans. And I had like a team of 15 or 16 asset managers who I'd oversee on the workout group, on the workout side. So I'm getting to the point eventually, right? So I'm getting to cannabis. So you're thinking like, well, what the heck does this have to do with cannabis, right? So in Lehman Brothers had this little fiasco. They filed for bankruptcy. That kind of ended my advisor dies, the company dies. I don't know. So I ended up at, this probably is probably is not a good way to say it, but I ended up at Burns and Levinson. And Burns and Levinson is about 125 lawyers. Most of us are based in Boston. We have a small office in Providence. And recently we opened up a small office in Denver as a result of our cannabis practice. When I went to B&L, what I basically did, I was doing workouts, bankruptcies, lending, finance, corporate, your typical corporate finance lawyer. And one of my first clients that I did a lot of work for had a small venture capital fund, and they had invested in a lot of different small emerging companies. And he had troubles with his investment. The companies weren't doing well. So we did a lot of work trying to help straighten things out for him. About the same time in 2013, he and some of his colleagues were part of a group, and they had submitted and received one of the 3 compassion center licenses in Rhode Island. And so in Rhode Island, they call their medical marijuana licensees are compassion centers. And at that time, they were all vertically integrated, and there were only 3. He brought us in order to do the private capital raise that he needed to get done, and just kind of help reorganize the company, get its corporate governance into place. We then, the head of our corporate department, my partner, Frank Siegel, he then got a cannabis client in, kind of wanting to do the similar stuff. And we got another one and another one. And we decided that given that Burns and Levinson was an incredibly entrepreneurial way, and seeing that so we're talking 2013 or 2014, there weren't very many law firms, period, in Massachusetts getting into this field. But many of the folks or lawyers who were getting into the cannabis practice were more on the regulatory side, licensing side. And for us, it seemed that there was a lack of corporate or finance lawyers with years of experience on the corporate finance side. And so we jumped right in and we created a department, and we've grown it and we've grown it. I mean, and fast forward to where we 2020, what we have done is we've built out a group that's headed by 3 partners for the most part, myself, Frank Siegel, and Katrina Skinner, who used to be a client. Actually, she was the general counsel of one of our banking clients, and she wanted to go back to practice law. So we brought her back in-house, and now she works out of our small Denver office. And we've trained a team of interdisciplinary lawyers. And one of the things when people say, like, well, what does a cannabis lawyer do? I think a cannabis lawyer does everything. And in that, I mean, it's less a specific type of practice and more it's a practice area. It's not like corporate law. It's not like insurance law. It's not like employment law. It's a industry group where we have to take all of the various things we've learned and we've experienced and we've practiced and kind of apply it to what the cannabis industry needs as it grows, which is a lot of tender loving care. So what does that all mean? And so, Laury, you've been running a company, a cannabis company, and you're getting closer and closer. In our typical day, and I think all of this here that I've listed, right, you've dealt with on a daily basis.
Oh, absolutely.
So I want to make it clear that I think if you're a cannabis lawyer, you have ADD on crack.
That's true.
I mean, basically, you do not know what's coming down the pike at any given day or hour. So, if to the extent any of you want to be a cannabis lawyer and to practice law in this area, this class is great. but it's really important for you to be, have experience and learn various other disciplines. So in my world, corporate law is important just to know how companies operate, how they work, how they set up their governance. I mean, this is extremely important. Finance, banking, lending. I mean, essentially, especially because cannabis is federally legal, it's so difficult to obtain financing. You can't just go list yourself on the NASDAQ. And so this is an area that is important, learning. And how do you document a loan? Well, we document loans all the time. Excuse me. Then we do so this is stuff we do at Burns. So we do a lot of M&A, which is mergers and acquisition, roll-ups, joint ventures. And so this is how companies acquire, sell, team up with other companies. And so we do M&A all day long, not in non-cannabis world, but in cannabis world. Capital raising. So on this, understanding of securities laws is really important, because at the end of the day, if you're going to raise capital, you're ultimately selling shares or of your stock or of your equity in the company. And regardless if it's publicly traded, there's still SEC laws that are imposed upon you in terms of what you can or cannot do. Real estate. I mean, real estate's extremely important in the cannabis industry, because essentially it's all about, it's the land, right? Whatever you're going to do in the cannabis industry, you need a lease. You need to own some property to do it out of. Whether it's going to do a grow, whether you're going to have a place for delivery, whether you have a retail store, or you're going to do an ancillary. So that's important. Sadly, there's always litigation. And so, to the extent that what you would want to do is be more going to court as opposed to sitting behind a desk and being boring all day and, writing letters and contracts and blah, blah, blah. There's a lot of litigation that goes on, whether it's product liability, class actions. There's a lot of shareholder disputes, because sadly, in this cannabis industry, everyone's greedy. It's a sad stereotype or generalization, but a lot of people who get into this industry become very greedy, and they start fighting with their partners. And there are more shareholder disputes than you would believe. And so that's why, going back to the top, it's really important that when you're playing the corporate structure, you kind of have to almost have a crystal ball. And I always say, whenever you're doing a deal, the best way to do it, whenever you're documenting or structuring it, think about everything that could possibly go wrong under the sun, because it probably will in cannabis, and then try to address it along the way. Tax is extreme. Like any company, anytime you do anything with a company, you always have tax issues. I don't know if you've talked about 280E at all.
Not yet.
But there are
today.
Oh, God help you all. So there are specialized provisions of the Irs Code that are applicable to anyone who's doing drug trafficking. Guess what? We're all drug trafficking in our own way, according to the federal government. But we'll leave our soapbox aside. Employment law, because you're all going to have employees. That's important. And then we get to the end, and I think this is extremely important: licensing and regulatory. Because at the end of the day, if you're in cannabis, for the most part, your company needs to have licensure in order to operate legally and compliantly. Not that everyone does. Caregivers, but you also have to understand the regulatory framework, because everything that we just went over, from corporate to employment, you have to understand that states and sometimes that local communities particular regulatory framework in terms of what they may allow and what they won't allow. And that will impact everything, So on the corporate end, there are some types of licenses where, in some states, there's a residency requirement, 51%. So you have to make sure you understand that component. On the lending end, some states will prohibit what you can take as collateral for a secured loan. On real estate, you need to understand the process because you don't want to just enter into a lease that doesn't have some type of out if you don't get the licensure. So licensing, you got to understand, you got to read it 14,000 times, what that state's or what that city's kind of zoning, regulation, statutes, everything under the sun, because it impacts how your company or how your, client's company will operate going forward. And I'm already behind time. I know, I'm sorry. So what I wanted to do was, so that's just some basic kind of what we do as cannabis lawyers. And I actually think it is a fantastic and hugely satisfying and extremely cutting edge area of the law or type of practice in the law, I should say. And I know we'll run out of time, but there's my contact information is on the back. And, feel free to give me a call or drop me an email. No, I can't promise I can get you a job before that happens, because I know that's what everyone always wants. But, we train everyone who comes through our doors as a junior associate is put on a cannabis client for at least for a couple different clients, couple deals, because we think it's such a big part of Burns and Levinson's overall practice. And so, anyways, to the extent I can help in any way, just give me a holler. So anyways, issues that arise. So there are specific issues that arise because of the federal illegality of cannabis. And I think one of the biggest issues is banking or lack thereof. So, people kind of like, oh, you can't get a bank account? Nope. Well, it's possible. And I won't go through all of this detail, but essentially there are certain provisions that federal departments have issued, certain guidelines that will allow credit unions and banks, for instance, take deposits. And I'm not going to go through, because we'll spend the next 4 hours talking about the Bank Secrecy Act. But we're going
to talk about it.
What's that?
I'm going to get into it.
Oh, good. Then I won't step on your toes. Then you
go. So don't worry about it.
But it is, I think, the one thing that you should take away from banking and illegality or legality or hurdles is you need to be super compliant your client needs to be super compliant when it's looking to open its doors and take in cash. And the reason beyond the regulations and keeping your licensure is if you're not compliant, then you can't have a bank account. And if you don't have a bank account, you can't be paying your workers in dollar bills and, fives and 20s. You get what I'm saying. I mean, and so the ability, one of the ways that many of these bigger entities and smaller entities have survived is they do get a bank account. And it is a process, and it's extremely can be extremely challenging. But hey, that's part of the price you have to pay as a cannabis company when you're dealing in illegal substances. So I forgot what I was. Other than the fact that apparently I can't spell because there's supposed to be a D in there. I see. Sorry, not a good. I don't proofread well, but anyways, so banking's an issue. One thing I do want to say is, so there's a lot of scam artists in the bankruptcy, that too, but in the cannabis industry, a lot of sketchy people. I can tell you right now that if you're a cannabis operator, you will have someone trying to tell you they can sell you, you get credit cards. You cannot. All of American Express, Visa, MasterCard, they will not let you ride those rails. That said, I've met with many a group who keep telling me, oh, yes, we can get you a credit card. They can't. They'll be closed down in 6 months. You'll hear stuff like, oh, well, what we do is we reroute your money to like France or the Cayman Islands, Jersey Island is the last one I heard last week. That's illegal. That's illegal. So if it seems to be too good to be true, it is, sadly. I think it was Mark. I think Mark was trying to sell me that one. You know who I'm talking about.
Yep, he would.
I was like, you can't do that. Oh, but it's okay. No. Anyways. Okay. So here are other issues. These are practical practice points issues that arise solely or almost solely in the cannabis world. Insurance. It is difficult and much more expensive to get insurance because many insurers are reinsured by insurance companies in England, where this is still illegal, or Bermuda or the Bahamas. And while they had allowed some reinsurance, that has since closed down. Directors and officers liability insurance, that is extremely difficult to obtain, and it's extremely expensive to obtain. Taxation, you're going to be enthused to learn all about 280E. I bless your heart. That's all I'm going to say. Bless your heart for going through that, Laury, because I barely know. Federal jobs. So this is important. To the extent you have clients who are contemplating being, directors, officers, major investors, shareholders in a cannabis company, to the extent they hold a federal job or sometimes another type of federal license, there's a possibility they could jeopardize that federal license for being involved with a cannabis company. So that's just something to be aware of. Retirement accounts and 401ks. So that's another issue. There are companies out there who are bringing 401ks to the cannabis industry. But so let me give you an example of how this impacts all of us, and we don't even think about it. So our law firm has our 401ks at Fidelity, or allegedly Fidelity, because I'm now going to like tarnish them. I also have some rollover accounts from previous employment, from previous employers at Fidelity. So over the summer, I get a letter from Fidelity. Where you have to close all your accounts. I was like, okay. So I go through all the process. Finally, I get someone, and basically they said, well, your firm, you have cannabis clients, you advertise on it, so we're closing your account. Now that sent everyone in my firm into an uproar. So as you can imagine, we got to a higher level, and I spoke to their head of risk. And what had happened was I was put down. So oftentimes when we form companies, sometimes we become the registered agent for service of process. On an application in Massachusetts, and I don't know whose, but in Massachusetts, you have to list all the officers and directors of a cannabis company. They have to go through the process of being vetted by the regulators. Well, some idiot put me down as an officer because they thought because I was a registered agent, that was the equivalent of being like a president or a CEO. trust me, it isn't, because you nowhere near get paid as much. But because of that, Fidelity has a tracker, and they're tracking people who are in their financial institution who are also deriving direct income from plant touching entities. So we went round and round and round, and I actually do have some plant touching equities, but never gotten any money out of it because it's a long-term investment. But they were actually in holding companies versus the actual plant touching. But because I was flagged as being an officer, and because I had all this retirement accounts there, they basically flagged me, and they're going to throw me out of their bank or their financial institution. And eventually we got them to say, no, just because your firm derives income from cannabis companies, we're not going to kick you out. But if you derive money directly and we find out, we'll kick you out. So
I'm surprised I haven't been kicked out yet.
I was surprised it took them that long to find me. I mean, because we're all over the internet, right? Yeah. It's not like we're keeping a secret, but
I keeps no secrets.
So that's just some things that may happen. Like you might have a client comes in and say, hey, they're closing me down. What do I do? Who can I sue? So, I mean, these are all real life examples. Credit cards, we talked about, you can't get credit cards. Stigma. Hey, in some instances, there's stigma attached to this. Even when this becomes, even when prohibition ends, it's descheduled, right? There's still going to be entities, businesses out there who are going to have nothing to do with marijuana, at least at first, because of the stigma attached to it, right? I mean, it just is what it is. So, not every bank will just suddenly rush and say, open their doors, say, come to us. A lot of banking institutions, investment banking houses, go down the line, they won't do anything involved with the sins. And that would be, it's usually like tobacco, guns. I'm not trying to opine on the Second Amendment. They just consider it there's a stigma attached to it, right? And adult entertainment too is apparently one of the stigmas. So, and probably cannabis will remain one as well going forward. So just keep that in mind. So essentially your equivalent of adult entertainer in the minds of certain very conservative financial institutions. Supply chain, very difficult. I'm just trying to kind of go quickly because I know I'm running out of time. It's difficult to create economies of scale because even when cannabis is legalized, right, every state will have their own policies, their own regulations, and what's allowable in one state may not be allowable in the other, like in terms of packaging. Certainly now we cannot make any type of economies of scale. You can't have like one grow house serving, let's even say you could go above the 100,000 square feet under canopy limits of that are set by the Commonwealth. You can't ship your stuff across state lines. Like you could have this giant grow somewhere in Massachusetts and have like a store in each of the New England states, but you just can't ship the cannabis across the state lines because of the federal legality. And so that creates hurdles to kind of economies of scale and creating financial savings. Because it's illegal, there's lack of federal bankruptcy protection, which many of the MRBs or cannabis operators really could use from now and then. Just keeping going. There's lack of access to the US stock markets to raise money. On the Canadian stock exchange, you can go, but that creates lots of issues. It's really difficult to go to a bank, even one that is providing depository services, to get traditional bank financing, which is so bank financing to get a loan, it's a lot cheaper than if you went to alternative financing. And lots of people, there are debt funds that are out there that have been created, but they are charging probably would be usurious types of interest out there. So okay, so let me just stop there for a second and catch my breath. But let me just make sure. I want to see if anyone has any questions for a second, because I could just talk endlessly, sadly. No? Okay.
I'm not seeing any hands.
All right. So just quickly, I don't know, do they know what an ancillary company is? I'm assuming yes, no, maybe.
I feel like they should, right? You guys know what an ancillary business is? And yeah, I see heads.
Okay, very good. So ancillary companies share, I mean, it seems odd, but they share, even though they're not plant touching, because they derive some type of money from offering services or goods to the cannabis industry, oftentimes the same issues that impact, direct plant touching companies will impact them. And so remember, advising clients in this industry, it doesn't just have to be, a grower, retailer, or whatnot. It could be, so for instance, we represent, trying to think what's a good example. So we represent Thermo Fisher, for instance, and they sell certain goods to or products to the cannabis industry, and it's a very, very small component of it. But we advise them as to where they might where they might trip themselves up, or about sort of their obligations vis-a-vis compliance, and so banks who provide services to the cannabis industry, those are ancillary. There's questions. Lawyers were ancillary services as well, if you think about it. So there's questions about whether 280E applies to them as well. And for now, that's a very good question. It really hasn't been settled. If what has been settled is if you're trying to create a company that is basically sort of extracting money from a cannabis company to a different company to try to avoid 280E, but really that company should be within the corporate tree, and you're just kind of creating this artificial entity structure to avoid the harshness of 280E law. There have been some tax court cases that have said, tough noogies. I mean, if you're only servicing one cannabis company solely, and I don't care if you call yourself consulting or a management company or something like that, that company can and should be hit with 280E implications. So let me. So what we're going to talk about quickly, and these are some excerpts from the present Massachusetts regulations, is this concept of a control person. And Laury, I assume you've kind of touched on it.
I call them PEDICs.
You call them what?
PEDICs, person or entity. Oh. Yeah. It sounds weird, but they're the ones who came up with those words.
Yes. And so here it is. It's laid out, what's a control person of direct or indirect control. And where this comes into play, it's when you're raising capital, because anyone who falls within this could potentially be a control person. It's when you're doing sort of a joint venture. It's when you're doing a sale, you're buying, you're acquiring. And really it's whenever you're doing some type of agreement, any type of contract, right? Because what they've done in their infinite wisdom, the Cannabis Control Commission, is, and I am being sarcastic now, they've created this concept where if you, let's look at number 6 here. So if you earn 10% or more of the profits or have the ability to collect more than 10% of the dividends, then you're technically a control person. So a lot of royalty agreements out there, IP licensing agreements, management agreements, whatever. And they'll say, okay, for our compensation, we're going to get, 5% of the gross. Well, I don't know what 5% of the gross equals to net, but they've created a system where if you're getting 10% of the net profit, technically you're a control person and you have to be disclosed and approved up front and put on the license application. But in my viewpoint, and this is my views only and not of the institution or Laury necessarily, what they've created by this definition is really a hodgepodge where anyone and like their pets could be deemed a control person because they are so broadly worded. And why this matters is because if you trip these regulations and for some reason some person or entity is deemed a control person but weren't properly vetted and approved, then you can be fined. Like, you're probably not going to lose your license. Let me just be honest, but you're going to be fined. And we've seen fines from 100,000 to like I think maybe 500,000 for one of the big boys when that whole tilt thing happened.
Oh yeah.
But never mind. I was telling a story, but I won't go there. But the point is, like, these are the things that should keep you up at night, and it impacts not just how you fill out your license application, but it impacts how you might structure a capital raise. So for instance, if someone wants to come in, they buy stock, they'll fill out, this is a private placement, they'll fill a subscription agreement and they'll say, okay, I want to invest and here's my $10. Now I get 10% of the company. Well, they can't get that stock until they've been approved. But in the Commonwealth, approval can take months easily, if not much longer. We've had one that took almost a year for a variety of reasons. And so what do? How do you take someone's money, but you can't actually give them in like ownership in your company, which is what they're trying to buy? And so what's come up and how we deal with this in the industry is this concept of convertible debt. So, and we run this by the commission, and they basically say it's fine. So what convertible debt is let's say someone's going to give you $1 million for 10% of the company. There will be an actual debt instrument and with an interest rate attached to it. And convertible debt's used all the time in a lot of venture capital. And I don't want to get into like how pricing and discounts, because that's beyond this. But what's important is there's always a trigger. So the trigger can sometimes be the next capital raise or their sales, or you're going to have a capital transaction where you're going to sell the company. But upon a trigger, then your debt will convert to equity. And so what we'll do is we'll have the trigger be in these types of instances when we're dealing with concerns of control, that when that person or entity is approved as a control person, then that's your trigger. And so the debt can be converted to equity. And now instead of having a promissory note, you have a stock certificate. And so this is a very commonplace practice that we see in the cannabis industry across the country as a result of this. And just, control issues aren't just unique to Massachusetts. Almost every state has some concept of who's in control, who needs to be approved by the regulators. So you got to be careful from state to state. I think the other place where control comes into place is the rule of three. And I assume you've all dealt with this. So the rule of
no hoarding rule.
What's that?
I call it the no hoarding rule.
The no voiding rule?
Hoarding.
Oh, hoarding. You know, it's an interesting rule, right? So when the 2016 referendum came and was passed, and then the enabling legislation, there was a mandate to protect the small business person, the mom and pop store, the homegrown, against sort of these monolithic MSOs, multi-state operators coming into the state. And what we did, the Commonwealth said basically, okay, you could basically have 3 medical retail stores and 3 adult use retail stores. And we can talk about wholesale delivery later, or never. But, you know, so that's created a really draconian limitation on the number of retail stores, which, you know, we can debate left and right whether it makes sense, whether it's actually followed. And, you know, like if you can go to Colorado and one group can own 25 stores or more, they can own more than 3. But you go to Missouri and there's a 5-store limitation. So states, I don't think I've ever heard 3. I think 3 is the most draconian I've heard across the country. But what it has created is a legal industry of trying to get around the rule of three. And it's I mean, we do it all the time, not purposely circumvent, but there are ways that you can be involved in more than 3 retail stores. So for instance, what a lot of people will do is so there's the threshold of 9.9999999%. And so what a lot of folks will do is say, okay, we'll own, you know, like 50% of or 100% of our 3 for our rule of 3, our 3 retail stores. But then they might enter into some type of consulting agreement and only get like a 9.9% carry. You know, but you got to be careful because you can't exert control with your 9.9%. And it's really, I think more time has been spent trying to figure out how to get around by MSOs, how to get around the rule of 3 than in terms of their operations and trying to improve operational standards and whatnot. And that might be a little bit of an exaggeration, but not so much from some of our clients. I don't know if you have a viewpoint of so Laury, you're the person that the mandate's for, in the sense of you have a homegrown local group, you know, you need, I don't supposed to say you need, but having protection against the much funded MSOs is really important, right? What do you think about the rule of 3?
I wouldn't say that the rule is directed towards me.
Okay.
I think it's directed towards somebody who isn't like me or my partner. My partner's he's ran businesses for, you know, his whole life. It's directed towards people who have actually no clue as to what's happening. Do I agree with it? No, because I like competition. You know, I'm a fighter. Mm-hmm. So I like to let the commerce decide for itself. And I also don't like putting people into victim mindsets. Like, I'm not a victim. I grew up in Haiti and I came here and I did it. And I hate how they keep like, we need to protect these people. No, you don't.
Well, I didn't mean it because you're, you know, a person of color. I meant
no, but like that's what happens with
mom and pop.
And SE. Yeah, even then, even that concept, like they need to be protected. They're victims. Are they though? I've met many sharp ones. I've met many MSOs who spent way more money than I would ever have to spend to get here. Does that make them intelligent? No, they're rich idiots. So You know, so if it takes you 20 million to get to something that took me $500,000 to get to, we got to really figure out who's intelligent here. And I think a lot of people in that category do. I don't think they need this much protection, to be honest with you. I think it's a little absurd. Even raising funds, you know, having to maintain 51% when you have zero assets, it's hard. And I think with the first retail location, at least, you should be able to give a big chunk of your money, your business. That's what happens in all other industries. So it really hinders our capacity to raise funds when people keep thinking we need to be protected, if that makes sense.
No, I listen, I agree. I mean, about a year and a half ago, 2 years ago, we had a private conversation with certain of the commissioners, and we were talking about like the lack of funding, you know, certainly for everyone, because there's no bank funding and there's no, you know, can't go to the capital markets, but definitely for people of color, EA, social equity applicants. And they're like, well, how do we raise money? What do we do? Maybe we can create a fund. And I kept saying to them, yeah, but okay, well, what's your collateral? Like, how are you really going to do this? Because if you raise money and it's part of like a state initiative, you know, because we do a lot of work for some of these like mass development, they aren't just going to be like, okay, here's, because you're a person of color, here's $250,000. We don't expect ever to see it again. Bye-bye. That's not how it's going to be.
Right.
And then what I said to them, which I don't think went over well, and I'm not the most politically correct human being, although now I'm not. But what I said to them is like, listen, there are lots of white people who have like 500 credit score and never going to get a bank loan and shouldn't ever get a bank loan.
Right.
I said, there's lots of people of color who fall into that same category, but, you know, because, or, you know, people who've gone to jail for the, you know, war on drugs and whatnot. I don't want
people,
anyone. And, you know, and there's tons of people who should not be trusted with a loan. And
you do not to be trusted with a loan. I detract the poor person comment then.
What's that? Yes. No. I mean, but there are just people out there who aren't business savvy, who don't have what it takes to build a company or be part of a company. And though, I mean, just because you fall within a particular group of people doesn't necessarily mean that, you know, you should be given that much of a leg up, or because you're never going to be able to, I'm getting into like,
I know what you mean, because I taught the social equity program. And one of the biggest problems was a lot of these students, I felt like I was giving them false hope.
Yeah.
Because you can tell who's going to be a successful business owner, just like, you know, for anything. If you could see a kid on a court and be like, you do not play basketball, get out of here. Go pick up a calculator and accountant. So you could just see things like that, and you see that they can't think about business. They don't understand the environment. They don't understand the market. They don't understand the regulations. Someone like that. It's not like they'll never get there, but they need a good 2 to 3 years of training before they're able to open their own businesses.
But let me though own my white privilege for a second, because I do know, I mean, even though I'm gay, so I get some little cred there for being, you know, underrepresented talent, I do have white privilege. And my partners at my law firm hate when I say that because they think it's something wrong, but it isn't. And this is real. And I know we're getting a little off track here, but I think this is important for the cannabis industry too, because there is such inherent racist overtones and undertones and under and overtones. And I think, you know, it is important for us to recognize, at least it's important for me to recognize I have white privilege. And it is going to be easier usually for me to get a loan than you are, Laury, even though we're both equal and have similar educations and whatnot, just because of the color of my skin. And so I want to be mindful of that fact. And all of your students should be mindful of the fact that, you know, that does exist. But at the same token, we have to be, we're here to be realistic and advise our clients properly. And just because you are a person of color or, you know, minority owned or LGBT owned or whatever, doesn't necessarily make you able to succeed in business, I guess is my point. And there's nothing more than that, but that's just
I
kind of the
agree.
point.
And I think it's also, this is also a slight tangent, but I think it's because they're trying to fix all the wrongs from the war on drugs with this program. And I think that everybody who went to jail for the war on drugs, like obviously they got caught, so they weren't great. Just kidding. I have friends who went to jail for marijuana. I'm like, dude, you suck. Like, look at you. How many times you been in there? But especially but that's getting into my family. But
my dealer used to live across the street, but that's a totally different story.
excuse me.
My dealer used to live across the street from us, but that's a different
Yeah.
story. Back in the old days, pre like 2012, allegedly.
And I definitely lost my full point.
Oh, sorry.
Which is all right.
My white privilege, I don't know, but I think as lawyers
weren't connecting the dots.
Pardon me?
You were commenting on people in jail not connecting the dots and not translating.
Oh, thank you. Yeah, thank you. No, thank you so much. See, this is a group effort. So a lot of people, some of these kids, they wanted to be rappers. Some of them might have wanted to be a doctor. And so when you come out, the only opportunity they have is to own a business. Obviously, they're going to try their only one shot. I think the impact program is a good step towards trying to make amends. But I think if you really want to make amends for the war on drugs, anybody who has a record leaving prison, if they have debts, we should create a fund to address that. We should be making sure that those who are actually harmed have other opportunities. I wasn't harmed. I wasn't even in this country. Like, you know what I mean? Like when I came here, I wasn't even in the realm of being one of those individuals. My business partner was. He got beat up by the police and got kicked out of jail for marijuana. But people, Haitians like me, it's not a situation. So I think we really need to tailor this program to really fit what we're trying to accomplish, which is helping those who've been harmed and those communities.
But and well, I agree, but I think as lawyers, right, we're trained to be counselors. We're not just there to draft contracts and whatnot. We are trained to be counselors, and I think it's important as you guys grow into your practice, wherever it may be. I think just as a general practice pointer, like not everyone who comes to the door and can pay your fees or your retainer you're not going to be able to help everyone. And I think as you grow older and more experienced, that's going to be something that it's a skill set that's hard to pick up. Like, okay, I really can't help you. And I will say this now, like, listen, would love to, but what you're asking me to do is either contrary to the law, it's impossible, it's impracticable, or more often than not, you just don't have a realistic view of the industry, right? I mean, I've been in this industry for like 7 or 8 years, and on multiple ends, and I've seen a lot. I've worked with many people who were selling the black and gray market, and that half the time, those are your master growers regardless. And that doesn't really faze me as much as people who just don't understand, like, this is, at the end of the day, it's not a hobby, right? The cannabis industry is not a hobby. It is a business. It is a very difficult business to get into. It is a very, very difficult business to succeed. And I hate to be so harsh and brutal about that, but it's true. There's limited money. It's a huge cash intensive business. And not everyone should be in it, but I do applaud. So I've been lucky enough to peer behind the hood of Major Bloom, and I've seen some other groups, and I applaud what you're doing, Laury, how you're doing a much more constrained approach where you're incremental. You're not being like, okay, I gotta go raise $50 billion or bust, where you're looking at this and taking in bits and pieces and try to build your empire.
Yeah, I used to go to the marketplace with my mother, and I learned how to barter since the age of 3. So I want to thank my mom for all my business negotiation skills and for really thinking methodically about things. It's all her. My mom had like 3 businesses growing up. She was always doing something.
Well, so listen, it's 9 o'clock. I know you have to learn all about 280E.
You guys got to learn about 280E, banking, SEC. There's a lot.
But I apparently only made through half, which is not surprising. So I'm happy at some other point to pontificate. I mean, talk some more, whatever you need. But certainly you all have my email. If there's specific questions about the practice or specific legal questions I can answer, feel free. So anyways, I want to say I really appreciate, Laury, you asking me, and to all your students for putting up with me. I'm actually very passionate about the industry. I use cannabis for medical purposes, and I use it for recreational purposes. I am a firm believer in the properties of plants, and regardless that they might make you high, there's so many medicinal qualities we don't know about, even if it's just to help you with your anxiety and just kind of chill out and, giggle and laugh one afternoon, because, life can be pretty hard. So so that's one thing I want to end with, but also importantly, remember, there is a huge social justice component to being involved in the cannabis industry, whether it's because of you're being anti-racist and fighting racism in your own way, or whether you're promoting the medicinal qualities. So, yes, we can make a great buck out of this, but don't forget, there's a lot of great, cool people you'll meet in this industry, and you can actually do some good work too while making money and getting stoned on the side. So that's how I'll end.
Oh man, well, thank you so much, Scott. And I would say that, thank you so much to Scott, because when I stopped practicing corporate law, I was like, man, who's going to help me when I need this, when I need somebody to look through and be like that, the partner eyes that I left. And Scott's always there for me, like always giving me that gut check, always there to read a contract. So thank you. He's like he's what you'll call a real one in these streets, y'all. So Mr. Scott already came. Last week, we ended in marijuana establishments. We were talking about 2 weeks ago. Do you guys remember what we were doing? We were talking about the operational requirements for adult use marijuana establishments. And I had left y'all off with I had just finished talking about marijuana social consumption. Remember that when you go to marijuana social consumption, they give you that card, that's that Buzz Killington card. Remember that? It's coming back to you. Don't worry. I mean, social consumption is great if you guys want to do that for your final, but it's just in real life. It's just so far away. All right. I mentioned briefly throughout the course that every marijuana product has to be tested before it could be sold. So no marijuana may be sold or marketed unless it's capable of being sold by an independent testing laboratory. They're going to test for the cannabinoid profile. They're going to test for contaminants as specified by the CCC. They're also testing for mold, mildew, heavy metals, plant growth regulators, and presence of pesticides. The issue with a lot of testing is that some companies that grow outdoors, they can't pass these tests because there are some growth, they're not animals, but fungus and those kind of lives that infect the plant that's actually good for it. They're like pro-life. And so that'll come up in the testing, and they'll have the cultivator destroy the plant. And what they'll have to do at that point is they'll have to put it in a form that is not that's not harmful. So what they'll do is they'll usually treat it and then extract it and make extractions out of it. So that's how a lot of the outdoor growers in Massachusetts have been passing the fact that a lot of their products aren't passing testing, which sucks. If you're all independent testing marijuana, independent testing laboratories have to have written policies and procedures. If you have a failed test, you got to provide notice within 72 hours. You have to keep your results for about a year. And the laboratory is either going to keep the cannabis or get rid of it, but they can't sell it, smoke it, or do anything else with it. And also, you guys, one of the first time I taught this class, one of my students really took to this material, and she and her father are opening up an independent testing laboratory in Worcester. And she said that as soon as things get to a certain point, any student of mine is welcome to go there and check it out. So again, I know the semester is coming to an end, pero this relationship don't gotta end, okay? So when things are going, even if you hear like Worcester Independent Testing Laboratory, hit me up and then we'll connect it so that you guys can come and see how she's doing it. It's pretty cool. All right, you can't sell marijuana if you're a testing laboratory because that's not your job. And the variance that's allowed is within a 10% variance. And we talked about you're allowed to, so if you have a crop that fails, you can do something to remediate it and then test it again. But you want to go test it at a laboratory other than the one where you failed. And testing laboratories still need all of the operational requirements and all of the written procedures that a normal marijuana business would have. So you need to have the written operating procedures. You need to train your agents. You need to have procedures for handling marijuana, for marketing and advertising. So it's the same exact policies for the marijuana establishments that I had spoken about previously. You're going to need them for testing laboratory. Okay. Good. Do you guys know what co-located marijuana operations are? Anybody? I'm glad you don't know. Good. A co-located marijuana operation is, were you going to say something? Okay, that wasn't, okay. A co-located is one that combines two, both a marijuana treatment center, that is a medical facility, and an adult use in the same facility. Those locations are called co-located marijuana operations. Let's see. So these are the considerations that you get. So everything I taught you in the beginning of this semester about medical marijuana and everything that I've taught you in the middle about adult use, they all apply to a co-located marijuana establishment. So what you do is you separate the business. So if you're a medical employee, you technically can't just be an adult use. You can't just transfer over to adult use. You have to undergo separate testing for adult use. Does that make sense? You have to treat them as completely different. You're going to have, we're going to go into the separate lines and how things are demarcated. But if you're an agent working in a CMO, you have to make sure that you're performing the task in accordance to your licensing. So if you are licensed, if you were hired by the retail spot, you can only do retail work. So you have to provide physical separation, if you're a CMO, between medical and adult use sales area. The separation can be a temporary or semi-permanent physical barrier, as long as it adequately separates the sales areas for MIPs and for the sales areas for marijuana products for adult use versus for patients. Have you guys been to a co-located facility yet? No? You'll notice they'll have separate lines. Boom. They'll have separate lines for those who are in the medical program versus those for an adult use. If you go to a CMO, unlike a adult use, you don't just have to be 21, right? If you're 18 with a medical card, you can get in there. Not only can you get in there, you can also bypass the line and go to directly the patient line. Part one. Part two, you don't pay taxes, whereas the person on the line next to you is paying taxes. So those are some of the benefits to going to a co-located area. And if you're in a region that has co-location, I would try to get a medical card just so I don't pay taxes. I mean, I know Americans hate people not paying taxes. I'm sorry, but just within this context, get a medical card. All right. I mean, you got to do the math at the end of the day. You pay $250 to go see Canacare docs, but there are always companies doing free medical exams to kind of give you your your card. And so if you do live next to a co-located, because it's a good thing to go there just for that tax benefit. What else? Oh, if you're a medical patient, you don't have to just go to the medical patient line. You can go to both. But if you're in adult use, you're stuck in one. You're stuck in the adult use line. You also have to have a consultation area. Because remember, in the medical use, it was all about ensuring that the patient was getting proper care and really utilizing the plant in the best way possible to help treat whatever they were going through. So in order for them to best do that, you're supposed to have a closed off personal area where you can go talk to a patient without people being able to hear. So you still have to do that in a CMO as well. The consultation area has to have a sign that indicates so. It has to be accessible by a qualifying patient or caregiver without having to traverse a limited access area. So you can't put your consultation area in the back of your cultivation facility, like, because then they'd have to roll through a limited access area. Again, you have to prioritize patient and caregiver identification, verification into the entry. So you'll notice that even going into the establishment of a co-located facility, they'll have two separate lines. They'll have a line to one line this way, one line that way, and that's to ensure that a medical patient does not have to wait long in line. I'm starting to feel like the patients are the Beyoncés of the medical world. What are we, Michelle? Get out of here. Okay, let me keep going. Patient supply. So if you are a CMO, you have to make sure, if you're a CMO, you have to make sure that you maintain product levels sufficient to meet your patient needs. Now, how do you determine what your patient needs are? If you've been open for less than 6 months, you have to reserve 35% of your products for patients. However, if you've been open for longer than 6 months, you have enough data from which you can assess what your needs are going to be, and you can rely on that data for the preceding 6 months. Does that make sense? So you always have to maintain 35% for medical. Yay, we're done. Isn't that exciting? Now we can get into the what we'll call ancillary stuff. We're out of Massachusetts regulations, y'all. Now we're gonna go into things that impact marijuana businesses throughout America equally. So first thing we're gonna talk about, and I'm glad that Scott came in and talked a little bit about this. We're gonna dive into banking. We're gonna talk about the Bank Secrecy Act and FinCEN. I think we have a movie.
Business owner in America.
Can you hear?
Getting a bank account to use for everyday business is a simple and straightforward process. But for cannabis businesses in the 29 states with some form of legal marijuana, it's not so simple. And here's why. The federal government still considers cannabis an illegal substance. Because of this status, financial institutions that provide banking services to state legal cannabis businesses fear the possibility of criminal prosecution under federal money laundering laws. Banks that choose to do business with cannabis companies incur additional compliance costs, including the monitoring of their customers' activity. This can become both costly and burdensome, so financial institutions frequently deny banking services or even shut down existing bank accounts with cannabis businesses, forcing them to operate entirely in cash. Running a cash-only business has some serious negative implications. For example, instead of enjoying the convenience of a paycheck or direct deposit, employees might receive a stack of cash as their payment. And vendors providing everything from electricity to cleaning supplies? Yep, a stack of cash is payment. And keeping all that cash on hand in the store isn't ideal, so they'll need to take measures to keep it secure. Otherwise, they risk becoming a target for thieves who love stacks of cash. There was a tragic example of this in Colorado in 2016 when a security guard at a marijuana dispensary, who was a U.S. Marine veteran, was shot and killed by 2 robbers. Overall, it's simply not a good idea to have so much cash floating around. Cash attracts criminal activity, creates a public safety issue for communities, and creates headaches for state regulators tasked with tracking legal cannabis sales. Legal cannabis businesses are paying hundreds of millions of dollars in federal, state, and local taxes. Because of the outdated federal banking regulations, these payments are frequently made in cash. The Departments of Justice and Treasury issued guidance in early 2014 regarding the conditions under which banks may work with the cannabis industry. Since that time, some credit unions and regional banks have made limited financial services available to cannabis businesses, but most federally insured banks still say no to banking with one of America's fastest growing industries. So what's the solution? Legislation in both the United States House and Senate called the Safe Banking Act would provide a safe harbor for financial institutions working with legal cannabis businesses, removing the risk that banks would be slapped with federal sanctions when doing business with the legal cannabis industry. There is strong support for this bill in Congress. In fact, 1 year after its introduction in 2017, the House bill had 90 co-sponsors, more than 20% of all House members, with a recent poll showing that 70% of Americans oppose federal interference in state marijuana laws. It is clear the public wants these laws to succeed, including safe access to banking. How can you help? Help us grow even more support for the Safe Banking Act in Congress. Contact your members of Congress and urge them to support federal.
That's enough. You're like, haven't I ever seen this before? Yes, you have. We're talking about banking, right? If we're talking about banking, if the federal government is going to tell us, like us as the, we can't use banks, they have to have authority, right? Okay. So what gives them all the authority to come regulate? So they have the right to levy taxes. They have the right to maintain armed forces, borrow money. So the Banking Act comes out of the right to coin money. All of that is part of it. So the Supremacy Clause basically says that if you, federal government, have the right to speak on a particular subject, you, state, can't speak on it unless we say you can speak on it, right? Here comes the Bank Secrecy Act, which is a federal piece of legislation that was established in 1970. Why? Because they were trying to get these money launderers out, okay? So in the 1970s, the BSA required businesses, this is the Bank Secrecy Act, it required businesses to keep records and file reports that were determined to have a high degree of usefulness in criminal, tax, and regulatory matters. Essentially, the Bank Secrecy Act turned all banks into Tekashi 6ix9ine, and they had to snitch if they heard of any criminal, tax, or regulatory matters, okay? So these reports were used heavily by law enforcement. Documents filed by businesses under the BSA were used by law enforcement agencies that were not just domestic, but also international. And it was used to identify, detect, and deter money laundering, whether it is in the furtherance of criminal enterprise, terrorism, tax evasion, or other unlawful activities. So they're trying to get everybody. FinCEN, have y'all heard of FinCEN? FinCEN acts as the designated administrator of the BSA. Does that make sense? They're like, Laury, what does that have to do with marijuana? Come, relax, okay? We're going somewhere here. So the BSA requires banks to do these reports. It requires businesses and individuals to submit these specific reports. So if you are an individual or a business and you're making a cash payment of over $10,000, that triggers the bank to issue this report. They're called suspicious activity reports, SARS. And it's basically take a deeper look as to whether this money is legit or not, okay? Also, if you report a foreign bank and financial accounts, they have to submit reports. And then if you have money service businesses, you submit reports too. So what is the Financial Crimes Enforcement Network? What is FinCEN? I like this picture because it takes money laundering very literally. So FinCEN. So we said the BSA was established in 1970. So about 20 years later, FinCEN was established. Its original mission was to provide government-wide multi-source intelligence an analytical network to support the detection, investigation, and prosecution of these domestic and international money laundering and money laundering crimes and other crimes as well. So in 2001, FinCEN's regulatory authority was expanded. And we all know why. That's because, we're trying to fight terrorism. This was post 9/11. And so FinCEN's authority was expanded in order to help fight terrorism. So the original mission was just surrounding money laundering and other financial crimes. The new mission you'll see is designed to promote national security through the collection, analysis, and dissemination of financial intelligence. And so FinCEN is doing a little bit more than money laundering at this point. So if you, a while ago, remember where I talked about Cole, Attorney General Cole, he submitted a memo that basically said if you are operating within a state that has a legal marijuana program, you will be, the Department of Justice will not be able to use its funds to enforce the Controlled Substances Act against you, but then you'll be safe-ish. Well, FinCEN wanted to get in the mix too, and they had their own guidance, right? FinCEN realized that the lack of banking was a real issue. It was a real public health issue. So February 14, 2014, Valentine's Day, FinCEN issued guidance setting expectations for financial institutions that bank with marijuana businesses. This was huge. It detailed guidelines, due diligence standards, and reporting requirements for financial institutions to follow if they offer financial products and services to marijuana businesses. Now, marijuana was legalized in adult use in 2016. And in 2016, I can tell you right now, there was only one bank that was even coming close to helping us in this industry, and that was Century Bank. And the reason, and a lot of people always ask, like, if FinCEN issued this guidance, why isn't that more banks aren't getting into the industry, right? Well, it's because of this guidance. It requires them to do a lot, and people don't like doing a lot. So, and with these guidelines, you were supposed to adhere to institution-specific factors, e.g., particular business objectives. You have to evaluate risk associated with offering particular products or services and the capacity of effectively managing those risks. So the specific obligations to banks, so banks that provide financial services to marijuana businesses, this is what they had to do if they wanted to make sure that they were complying. First, they had to obtain and review marijuana-related business and parties information that's found on applications, license, and registration documents. So they basically go online and they'll go online and they'll look at, CCC documents, DPH documents. They'll look at your legal, if you're a professional or lawyer, they'll look up the Board of Bar Overseers to see if you had any kind of penalties. So they're going to do anything that's public. If you're a marijuana business, the bank is looking at all of that to make sure that they're not violating FinCEN by allowing you to bank with them. Another thing too, they have to develop an understanding of the business's normal and expected activity, including the kind of products that they sell and the consumers that they serve. Because if things start changing, the bank needs to be able to let the feds know that, hey, this person might be breaking the law. They have to monitor for suspicious activity, including guidance specified red flags. And they have to routinely update customer due diligence information that's commensurate with the risk. So all of this requires the bank to basically train people, start a whole new department, create forms. Like, this is literally what's been stopping them. It's the administrative costs of providing these services within a very risky federal regulatory landscape. Is that making sense? It's too risky for them, despite this little way out. So what are these red flags? So the red flags that were identified in the guidance were somebody who's appearing to use the license as a pretext to launder criminal activity derived funds. So imagine if you sell weed for real in the black market, and now you have a legal market, and you're maintaining both businesses. So if you're using that legal business as a method of like quashing the black market money, so to speak, that would be problematic as well. So an inability to demonstrate a licensed business operating consistently under law or a legitimate source of significant outside investment. So if you look like you're not operating in compliance with regulations and laws, or you're getting money randomly from places, then that's getting problematic. I've had many clients who could not prove where they got their money from. So that was hard. Okay, concealing or disguising cannabis involvement. So a lot in the beginning, a lot of us would go to banks and we would pretend, we would say we're a horticultural store. We would never say we're a marijuana business. And that would be a red flag. Engaging in international or interstate activity, including making/receiving out-of-state cash deposits or interstate transfers. Lastly, if you're purporting to be a nonprofit while engaged in commercial activity, this is not a big deal anymore. But in 2012, when medical was legalized, companies had to be nonprofit. And do you know how difficult it is to raise money in a nonprofit structure when you can't give people shares? It's tough. So what these companies were doing is they would form these shell companies, and the shell companies would operate for profit and would be would basically be the company operating, and not in the nonprofit would just hold the license. Does that make sense? But again, in 2018, Jeff Sessions said, "No, I'm repealing all memoranda that have been issued, including FinCEN guidelines." And now you're like, Laury, why'd you spend so much time talking about guidelines that don't matter anymore? Well, relax, not so fast, because Massachusetts got us. So the Massachusetts Division of Banks, the DOB, conducts regular examinations of state chartered financial institutions for compliance with applicable laws. Have you guys heard of the DOB? The DOB? Sounds like a rap group. You down with DOB? Okay. The DOB examiners review whether financial institutions working with marijuana-related businesses are following the FinCEN guidance. Now, you guys, I think I might have told you, even though Jeff Sessions repealed these memoranda, our Attorney General in Massachusetts, Lelling, basically is operating as if Sessions did not appeal them. So in Massachusetts, operationally speaking, or effectively speaking, we are still adhering to the Cole Memorandum guidelines. We're still adhering to FinCEN guidelines, since ultimately Lelling is the one who has to come down and enforce it anyways. Does that make sense? Okay. So now so let's get back to DOB. They make sure that you're complying with FinCEN, and adherence to FinCEN guidelines and recommendations will satisfy the requirements for the Division of Banks for institutions under its supervisory jurisdiction. Okay, so what are the banks working with marijuana businesses in Massachusetts? Avidya Bank is new to the game. They're fairly recent. We have GFA Federal Credit Union, Bay Coast Bank, Century Bank. There's a credit union that wrote me today. I don't know where I put it. Who they at? Southbridge Credit Union. So they're trying to get in the game too, but I'm going to have to talk to them personally to figure out who they are. But if you want to get into marijuana, these are the ones who are providing banking services. And the services they're providing are like cash. They pick up your cash. Debit. Some of them allow you to have debit. All right, any questions? Good. Now we're getting into taxation. You guys have heard me talking about Irs Code 280E for the longest. Now we're finally to it. What does 280E tell you? It basically says you can't take any deduction or credit. No deduction or credit will be allowed for any amount paid or incurred during the taxable year in carrying on any trade or business, if such trade or business consists of trafficking in controlled substances. Boom. Movie time.
You've probably heard about the green rush sweeping the nation. Although the cannabis plant is still federally illegal, in the 29 states plus DC where it is legal for adult or medical use, businesses are now legitimately growing it, selling it, and everything in between. You may think these businesses are swimming in profits, but what you may not know is that they're being taxed at an insanely high rate, thanks to a little thing called Section 280E of the IRS Tax Code, making tax season for a cannabis business owner a real bummer. Imagine paying an effective tax rate 3.5 times higher than the business next door to you because you were forbidden from taking normal business deductions, such as payroll, rent, and other common costs of doing business. Cannabis dispensaries and cultivators are paying an effective tax rate of 70% or higher. By comparison, the corporate tax rate established by the Tax Cuts and Jobs Act of 2017 is 21%. The effect of this is that licensed cannabis businesses cannot invest as much in capital improvements or things like employee raises and benefits, hiring more employees, expanding operations, or giving back to the community. The disadvantages are numerous, from high turnover to higher prices, which drives customers back into the criminal market, and criminals don't file tax returns. So why does Section 280E exist? It's kind of a funny story. In a 1982 U.S. tax court case called Edmondson versus Commissioner, a meth dealer argued and was able to write off egregious expenses, including his telephone, car mileage, and personal entertainment expenses. Shortly after, Congress then amended the tax code to bar tax deductions for doing business connected to the sale of any Schedule I or II substance. Clearly, it was intended to penalize criminal market operators, not state legal compliant cannabis businesses. In today's world of state legal cannabis, this antiquated code is nonsensical and absurd. Cannabis remains a Schedule I controlled substance according to the federal government, so this penalty applies to licensed cannabis businesses that operate in compliance with state laws and regulations. This means real problems for state legal cannabis businesses who are staying compliant while attempting to grow. Meanwhile, it has no effect on illegal operations that don't file tax returns. Reforming Section 280E would result in a net increase in federal tax receipts over 10 years, meaning everyone benefits by reducing the tax burden on cannabis businesses, including the federal government. The bottom line is that the cannabis industry is thriving and growing in many ways, but we still have many hurdles to jump and barriers to navigate as we work toward being treated fairly, just like any other industry in America. It's also how the majority of American voters want to see us treated, including 82% of Trump voters. Overall, it's a cruel irony that these provisions don't apply to any other illegal businesses. Even a bank robber could write off the cost of their getaway vehicle. Meanwhile, cannabis businesses can't even deduct many of the costs incurred in staying compliant. Do you want to see 280E fixed so that the cannabis industry can thrive? Contact your members of Congress and ask them to support the legal small business.
All right. So origin of Irs Code 280. They talked about it a little bit in that video, but Edmondson Decommissioner. You guys like, what the hell, a case? Class is this? All right. So what happened in 1974, during the taxable year of 1974, Jeffrey Edmondson, the defendant, he received 1.1 million amphetamine pills, 100 pounds of marijuana, 13 ounces of cocaine from a supplier on consignment. On his 1974 return, Edmondson reported that his cost of goods sold for these products was $105,300. And I'm like, damn, it was 1974. What kind of prices are those? 100 pounds of marijuana? Okay, let's keep going. He itemized deductions, including at least 2,000 miles he put on his car, the cost of a scale to weigh his product, packaging costs, around $200 in long distance and local business calls, a portion of his rent for his home office. All right, what's the ruling? Well, the court decided that he was entitled to both ordinary and necessary business expenses. Even though he was running an illegal operation, it was still a business operation. And then on September 3rd, 1982, remember this case? What year was this case? 1981. 1982, Congress was like, not so fast, okay? And they passed Irs Code 280E, banning businesses that traffic in Schedule 1 and Schedule 2 substances from taking their business expenses / credits. So Jeffrey won, but he ruined it for all of us, okay? So, so what exactly is 280E? No cannabis will receive deductions or credits for any of their business-related expenses. Normally, businesses can deduct their ordinary business expenses under Section 162. Normally, businesses, theoretically, 280E was meant to deter drug dealers, right? But it didn't work. It just made them not report anything at all. So the effective tax rate, like we saw in the video, can be upwards of 70%. Entrepreneurs can deduct costs associated with growing the plant, but cannot deduct costs related to the retail business. Some businesses, due to poor financing, pay tax rates of 100% or more on their profits. Ain't that nuts? The IRS imposes tax penalties of 20% of underpayment amount. And while we're here, you guys, thank Macaulay Culkin for my English. I saw that movie Home Alone so much that my English got so much better after that film. So you're welcome. Thank you to Macaulay. So the IRS imposes a tax penalty of 20% of underpayment amount. So you could end up owing way more than 100%. So what about marijuana businesses conducting non-marijuana business? I think that Scott alluded to this briefly. So let's bring up another case. Californians helping to alleviate medical problems, Inc. This is called the Champ case, and you will hear about this case all the time. This is what happened in Champ. In Champ was a caregiving facility that provided services to people with debilitating illnesses, and it was founded in San Francisco in 1996. In 1996, California legalized medical marijuana and instituted a medical marijuana program. And Champ was providing services as in compliance with that program. Half of the members from this group suffered from AIDS, and the others were afflicted with very serious diseases. Champ's members paid monthly fees sufficient to allow Champ to break even. The marijuana services that they provided members with medical marijuana, and they made sure that all their patients had medical cards and that they were all registered with California. The non-marijuana services was one-on-one counseling, daily lunches, hygiene supplies, yoga lessons, and internet access. So in 2002, Champ discontinued operations and filed income tax with the IRS. IRS found a deficiency of approximately $355,000 and assessed a penalty of $70,000. So this deficiency was reflected of the numerous deductions that they had taken, such as salaries, maintenance, and rent. The IRS said that all of these otherwise allowable business expenses deductions were precluded by 280E because it prohibited deductions related to trafficking of controlled substances. Champ brought the suit in the U.S. Tax Court, and the U.S. Tax Court held for Champ in part and the IRS in part, and ruled that whether selling non-marijuana merchandise is a separate business from selling marijuana merchandise is an issue of fact that depends on, among other things, the degree of economic interrelationship between the two activities. If, however, selling marijuana merchandise were considered a separate business, then the expenses of that business would be deductible. So basically, the court held that Champ operated two separate businesses, one marijuana business, one non-marijuana business, and was allowed to take ordinary deductions and credits for the non-marijuana business. So now at this point, you're like, why isn't everybody doing this, Laury? Why don't people just put the license in one business and then put the put the employees and all that stuff in another business so that they can make sure they can take their deductions and their credits, right? That's what you're thinking. That's called the management company model. So a lot of times, especially in medical, when they were forced to be nonprofit, marijuana businesses sometimes created two separate lines of business: the marijuana business and the non-marijuana businesses. Very much so like Champ. This allowed the non-marijuana entity to deduct employee salaries, rent, and other normal business costs. But somebody had to place restrictions on this because companies were going crazy. They were separating these businesses and doing a lot of activities that are very closely related to the marijuana business. And so let's go to Alterman Decommissioner. So what happened here? In Altermeds was a cannabis business that offered marijuana products for sale as well as non-marijuana products. They had pipes and glassware, etc. In 2010 and 2011, Altermeds filed taxes and applied normal tax deductions to its business expense. The IRS audited Altermeds and found a deficiency of $157,821 in 2010 and $233,421 in 2011. And they held that Altermed was not eligible for those business expenses. For those business deductions. Altermeds claimed that they had multiple businesses, one with one of their businesses selling non-cannabis, one being cannabis. They were assessed the tax penalty of 20%. Obviously, they went to court. The ultimate ruling from this case that came out of this case was that although Altermeds claimed to have separate businesses, with one selling their non-cannabis merchandise, the tax court did not find the business to be distinct enough from the cannabis dispensary. So in Champs, they were giving hygiene products, they were giving them lunch, they were giving like one-on-one counseling. Here, they're selling pipes and bongs. And the court said to prove that a business is distinct, the company must be able to show that there is a separate business and account for those expenses that are tied to each business being conducted. They held that the non-cannabis products sold were sold to complement selling cannabis and were not eligible for any deductions. So the interrelationship between bongs and marijuana is of such a degree that it would fit into the marijuana business's model to sell it. Whereas one-on-one counseling and hygiene is not that interrelated to a marijuana retail shop. Does that make sense? It's still a gray area. And then to add more to this, recently, this was I want to say around February, maybe not around this time, when COVID first hit, Section 471C came out, which kind of helps operators deal with Section 280E. So businesses that are subject to 280E may be able to adopt an accounting method provided by Irs Code 471C that may relieve certain small business taxpayers from the tax liability created by 280E. So essentially, to determine what your cost of goods sold is, you're going to be able to determine how you calculate your cost of goods sold yourself. Does that make sense? You basically, the way that this works, and this is brand new, my accountant is the one who brought this up to me. The way it works is you create your own SOPs for accounting. And within those SOPs, you define how you calculate, how you determine what your cost of goods sold is. The IRS will then have to determine whether you're adhering to your own policies and procedures as opposed to like a general COGS. Does that make sense? Now, this is a very risky strategy. I'm taking the risky strategy. I'm not telling you to take the risky strategy. I can take this risky strategy because even if I get slapped with like overpayment, my business has a lot of other aspects that hedge the risk on this because I have non-retail aspects. I'm cultivating, I'm making infused products, and I retail. So because of that, a lot of like the taxes on one location get spread around. Is that making sense? I can allocate more. Many factors must be considered to determine a business's eligibility prior to adopting this strategy. So you have to do the gross receipts test. Generally like a prior 3-year rolling average of less than 26 million in revenues required, subject to aggregation rules, of course. Entities required to produce an applicable financial statement within the meaning of section 451B3 may be required to conform to GAAP. I don't know if you guys are familiar with GAAP standards of accounting or the IFRS, rather than the books and records of the taxpayer prepared in accordance with the taxpayer's accounting procedures. Is that making sense? So they're going to really, so what the IRS is going to do is when they're trying to determine what your COGS is, your cost of goods sold, they're going to look to your own policies and procedures, which of course have to be kind of legal. Not kind of, fully legal, you guys, fully legal. Get out of the gray area. So that's what this is. Is that making sense? At the end of the day, y'all, you have to use whatever you can to kind of save as much money as you can to kind of reduce your tax from 70% to something that's more reasonable. All right. How much time do I have? Are you guys telling me that class is over? Give me 4 more minutes, please. You might never see me again after this semester. That's how I'm like a Haitian mom. I know how to guilt people. You'll never see me again. All right, business structures. You guys have taken business entities and organizations, right? That's why I made you do this, so that when I get to this point of the class, it's not too much. So allowed business structures in Massachusetts, you can have any limited liability structure, basically. Corporation, cooperative corporation, LLC. You can't be a sole proprietor. Do I have to explain why somebody would choose a corporation over an LLC? You guys are good with that, right? I know there's maybe a couple of you guys who are taking business fundamentals, but by now you know what a corporation is. Okay, so I can move through these. So, okay, I can go through these. I'm gonna leave these in. If you want me to stop and explain any of these concepts, please tell me. But again, you guys took only thing I want you guys to remember when you're choosing your structures, because you're going to tell me why you chose your structures. You're going to say, I'm choosing a corporation because the corporation is taxed at 21% now, right? As opposed to, and the corporation provides me the largest liability shield. I don't have to report my taxes on my personal tax returns. But if I'm an LLC and I elect to be taxed as a partnership, then I have to report my taxes directly on my own tax report. That means that me as an owner, I'm no longer shielded. Underpayment penalties are great. You don't want to be slapped with those charges, because then the IRS will come after your own stuff. And so that's why a lot of times I'll tell clients to either form as a corporation or form as an LLC and elect to be taxed as a corporation. So you get shielded from tax liability on both fronts, and you get to operate the business without the rigid structures of a real corporation. Does that make sense? So on the day of the exam, and I'll go over this again next week, when you choose your structure, I want you to tell me, Laury, I have chosen a corporation because of this tax reason. Since I'm going to be a retailer, right? Since I'm going to be a retailer, I would prefer to be a corporation because I think they have the greatest tax risk. But I'm going to do a partnership as a product manufacturer cultivation facility because they can take more deductions. It's less risky. So that's the kind of analysis I want you to be able to make and also be able to do for your client. If a client comes to you like, Laura, how do I structure this? First thing I'll ask them, like, what are you doing? A retail store? What? Dude, you need to make sure you're really protected. I would do a corp. If you say product manufacturing, I'm like, you could get away with an S corp. But we could talk about that. Do you have any questions about that? No? Well, then I can let you go because this is literally the same slide that I stop before the review every year. It's kind of ridiculous. So what we're going to do is next class, I'm going to go over securities laws and then fold it right into our review. And your homework is choosing your groups and letting me know who's on what group. This year, please, you guys, let's keep these presentations to 5 minutes. I know every year I'm like 5 minutes. People are in here for 15. I'm like, it literally does not have to be that deep. And I will talk to you guys soon. Have a great weekend. I hope you guys chilling out. Probably not. Finals are coming up. But I mean, who cares? We out here. This is my silver lining. We're here. We're healthy. We're pushing forward, and the class is almost over. That's probably sad. But I will talk to you guys later. Have a great weekend.